Welcome today to the first webinar in Venable's post-election webinar series. As we look ahead to a new political landscape, we'll offer insights into the key regulatory and policy changes expected under a Trump presidency. Today, we start with our presentation on working with the new administration, what to expect in 2025. We are offering today's presentation for continuing legal education credit. There will be a password that I mentioned twice, once in the middle and once at the end, that you'll need in order to receive that credit. We're excited to have you here today as we help think about navigating the new administration and what to look forward to. I'm Ron Jacobs, the chair of our political law practice here at Venable in our Washington, D.C. office. I'm joined today by three of my distinguished colleagues to help us think through what working with the new administration will look like. And when I say work with, I mean, of course, in the sense of both those who support and even those who do oppose the president's agenda, who want to try and work collaboratively and try and find solutions or be prepared to deal with policy outcomes that they don't like. Our goal here today is to help understand what might be coming down the road, who will be in those key positions that will make a difference, and what are some of the key priorities that we'll be thinking about and wanting to consider. So let me introduce my panelists that are here with me today. We've got John Drzwicki, Kyle Scherer, and Ariel Wolf. Just a little bit of background. John has spent many years on Capitol Hill, including as a policy director and deputy chief of staff to the Republican Policy Conference, and in the personal offices of several key members of Congress before that. So he's really well versed in everything Capitol Hill and how that intersects with the administration. Kyle works on environmental matters and energy matters here at the firm. He chairs the firm's Native American law and policy practice. Kyle was the principal deputy general counsel of the White House Council of Environmental Quality during the first Trump administration. He also served in several roles, senior positions in the Department of the Interior. Has been there, done that, so to speak, in terms of understanding sort of how things work in a Trump administration. Ariel Wolf is the chair of our Autonomous and Connected Mobility Group. He served as counselor to the Deputy Secretary of the Department of Transportation during the last Trump administration, and also had time on Capitol Hill as a senior policy advisor in a senator's office. So hopefully we can bring a wide range of perspectives about the administration, some firsthand experience, and sort of seen it all anew again, and provide some good insights for you. I think we have a lot to cover today. We have a lot of different areas we want to talk about, but we'll also try to make room for questions. So if you use the Q&A box to type in questions that you might have as we go, feel free to do so, and we will try and answer those to the extent we can, either throughout, or we'll maybe try and reserve a little bit of time at the end as well. Also, we have a variety of links that will come out to materials with the program, including a slideshow that presents a lot of information about the different nominees that have been nominated already, and those that we are expecting, sort of some flow charts for process as well. We're not going to do a slideshow today. Our hope is that this can be a much more of a conversation kind of among the four of us talking through some of these different issues. But certainly we hope you'll use those materials to help you understand and digest what's going on. So with that in place, let's dive in and get started. I think John will start chatting the two of us first. As I just mentioned, we do have a lot of slides that will go out with the materials that talk about who's who, where, and what. But John, what are some of the big picture takeaways that you've seen from sort of the Trump nominations so far?
Yeah, as far as surprises go, I mean, to me, I think Matt Gaetz was really the only big surprise, and he's withdrawn, pretty quickly. We knew that it was going to be a mix of people that were either close to him before, or people that, helped him out on the campaign trail when you look at RFK Jr. As far as, them actually being confirmed for the role, I don't think that the Senate's going to just blanket start opposing Trump appointees left and right. Obviously, given DOD and Pete Hegseth's issues over the last couple months, he kind of seems like the top target now as somebody that might not make it through the process. But, there's been a lot said about RFK Jr. and his experience to be able to run HHS. And again, I don't think the Senate is really going to go after a lot of these nominees unless there's a real glaring problem there, like there is with Hegseth. So, we have a slide deck that we've been updating that we'll send around to everybody. But, there, like I said, there's a mix of people that I think are serious legislators that deserve the position. People like Marco Rubio as Department of State. I think everybody can kind of agree that that's a fit there. Doug Burgum from North Dakota in Interior. Again, those are picks, but you knew there was going to be the couple of outliers as well.
And so we'll obviously talk a little bit more with Ariel and Kyle about some of the specifics in their various areas. John, what about sort of the congressional leadership? How's that shaking out? What are you seeing? What are you thinking it's going to look like?
Yeah, so not much has changed from the Republican leadership in the House. I would say, except for Elise Stefanik moving over the administration as ambassador to the UN. They filled that spot with Lisa McClain from Michigan, who's a relatively newer member, but now on armed services and very thoughtful member. So, she'll do a good job in that role. The speaker still, even though he got the endorsement from conference, still needs to win a floor vote, which we've kind of seen over the past couple of years be a little bit more exciting than it used to be. But I don't think there's any issues right now with Speaker Johnson retaining the gavel. And obviously with Mitch McConnell stepping back in the Senate, we now have John Thune, who's heading things up over there for the majority in the Senate. So, yeah, I mean, Trump is kind of the de facto leader of the party now, given the trifecta that he has in Washington. So, to the extent that the speaker's power is kind of diminished a little bit from, 2024 to 2025, he's not really the guy that's, stopping the Biden administration. He is now the guy that has to kind of make sure that Trump's agenda gets passed through Congress, and takes his orders from the big guy up top. So that's kind of how it's shaken up right now.
Yeah, John, one of the things that's interesting is the president elect has picked some people from the House. The margin there gets potentially pretty narrow. What are things to look out for there, and sort of some of the risks as you have Stefanik and others potentially joining the administration?
Yeah, so they'll be down. So it's a 5-seat majority. After the election, they'll be down to I believe it's a 4-seat, or I believe it's a 1-seat majority once everybody resigns that needs to resign that's going into the administration. So you'll essentially have a 1-vote threshold there to pass anything. I think you're gonna see a lot of what you saw over the past 2 years out of the House. Very difficult to pass rules, and as you may or may not know, I mean, the House to bring a bill to the floor, it's got to go through the House Rules Committee and pass, through there. They decide how long each side gets for debate, how and what amendments are made in order for consideration on the floor. And it's been difficult over the past 2 years to pass a rule. And if you don't do that, you have to pass things by suspension of the rules, which requires 2/3 of the whole conference or Congress to agree to vote for the bill. So look, the House Republicans are really focused on, and the Senate to that extent, are focused on reconciliation as being the real key to passing legislation.
So tell me about reconciliation. I think we hear about taxes as being something high on the president's agenda. Reconciliation, for a non-legislative person like me, means something about the budget and the money. But help us understand what that means and what it allows to be done.
Yeah, so reconciliation's a very complex and confusing process that pretty much just says that the House and the Senate have some budget discrepancies that they need to work out. in terms of spending revenue, and revenue and expenditures for the federal government. And what happens is it allows passing a bill to kind of rectify those discrepancies, allows us to break the threshold in the Senate. So you only need 50 votes to pass it instead of 60. But to get there, you need to first off pass a budget. You need to pass instructions on how they're going to curb spending, which the both chambers will try to do very, very early in 2025, and will be very difficult to do. We don't really pass budgets anymore, not ones that are serious. So once you go through that process and you actually get the opportunity to draft a reconciliation bill, you have to make sure everything is tied to federal spending or revenues in some sort of way. And there's the House or the Senate clerk is kind of the safeguard there to make sure that everything is tied to government funding in some way. So they kind of have a lot of power in this process. An unelected kind of career staffer really holds all the keys to saying what's in and what's out of a bill. But right now you have Senator Thune, who has said as early as I think last week that they want to get 2 reconciliation bills done, which they can do because they didn't do a budget last year. So this would be for FY25, and then they can do FY26's budget. So they do get 2 bites at the apple here on a reconciliation bill. And Senator Thune wants to do immigration and energy as the first reconciliation bill, and then address taxes the second time around. The House is, supporting that right now, but there's a lot of hesitation behind the scenes, mainly because like I said, it's very, very difficult to pass a reconciliation bill. We did when I was up there, we did Tax Cuts and Jobs Act. Democrats did American Rescue Plan and the Obamacare through reconciliation. And people who've been around this town got to know that those weren't easy things. It wasn't a rubber stamp that the president wanted and it just went through. There's a lot of issues on a lot of these bills. And again, with a small majority in the House, is going to be very difficult. I was talking to a member of Congress this morning where he was like, okay, imagine getting 400 or 217 members to agree to go to dinner, agree to go pick the same restaurant, and agree to order the same thing for dinner. That's what they're looking at right now for reconciliation. So it's very difficult.
No hard lift at all for the speaker to try and pull that one off then.
No.
Got it. So the other thing we hear a lot about is sort of the deregulatory efforts that we're expecting from the administration. And sort of part of that perhaps is regulations that have been implemented already by the Biden administration. There's the Congressional Review Act, which basically allows both houses to pass a resolution that disapproves of the regulations, and then the president has to sign it. There's a 60-day window, so it's kind of a narrow window when this gets to happen. And so it really tends to happen only kind of when there's a change of administrations, right? Because the president's never going to veto his own regulations, basically. So we're in a window where the Congressional Review Act comes into play. Are there things that we think are going to kind of be reviewed and gotten rid of on the regulatory front that sort of allow the new administration to start with a clean slate?
Yep. So, the President-elect Trump will obviously do a lot of deregulation through executive order on day one, like we saw last time. I think, the stuff for the CRAs will be used largely as like a political tool. I mean, when I was up there, we used them as things that we wanted to get Democrats on the record as, hey, we know you're against this. We want to get you on the record as opposing this. Or things that just kind of bolster the message we have, which is why I'm hearing a lot of the CRAs that come out early on are going to be tied to energy. So you got methane rule, clean power plan, tailpipe emissions, There's also a few financial services things. And hearing that, you get the look back provision where you get to kind of go back in time and pick some regs there to target. They're eyeing regs from August as that look back period. But yeah, they're kind of working in tandem with the administration to see what can be done through executive order. And just real quick, as I'm seeing a few questions because I can answer them quickly. No, Congress does not have to do the CR before reconciliation. It's one of the problems that people who have been here Democrats are kind of licking their chops with Republicans wanting to do a CR until March. Go ahead. Try to figure that out while you're trying to do reconciliation. Some of the immigration issues, they're trying to finish the border wall, and they're also trying to say that limiting immigration has a direct tie to federal spending due to the government benefits that undocumented immigrants would have. So again, that's going to come down to the clerk you'd have to make that case to the clerk, but they're kind of making that early on.
It really is a pretty expansive concept, I guess, when it comes to things. Yeah, absolutely. Well, John, thanks for that perspective on sort of what the legislative branch might do as it interacts with the executive branch. Let's I'm going to turn it over to Kyle now. Kyle, now that we've heard about kind of the legislative branch, let's talk a little bit about sort of the administration. And obviously your background is energy, natural resources, the area where you focused on. What are some of the agency priorities in that space that you really see being at the forefront of the new administration?
Thanks, Ron. So, I thought I'd maybe provide a sort of a high level overview of what I think we might be able to expect from sort of a second Trump administration in those spaces. And again, I can really only focus on the agencies or offices that I'm familiar with. So, CEQ, White House Council on Environmental Quality, Interior, EPA, and the Army Corps of Engineers. And, they do a lot of things, but, they're somewhat particularly focused on energy and natural resources development. So I think, you saw this throughout the campaign that President-elect Trump and his surrogates sort of spoke of an America First energy plan. And I think big picture, that means, increasing domestic energy production and reducing the industry's regulatory burden. And I think if successful, those things impact national security as energy independence makes us less reliant on foreign sources of oil and gas. And I think, the hope is that they also reduce costs, not only at the pump, but on everyday items as shipping becomes less expensive. And, in an ideal world, savings are passed on to the American consumer. So I think the first Trump administration was fairly successful in pursuing what, was sort of then described, at least at Interior, as an energy dominance agenda. And, so we've already got, something of a blueprint for how the second term might look. But I do think that the statutory and regulatory landscape looks a lot different today than it did in 2016. So, I was at CEQ, which, NEPA is a big part of that world. And I think if you just look at NEPA in 2016, the statute had calcified, right? And I think both parties would agree with that. It's implementing regulations hadn't been updated since 1986. There really hadn't been any substantive amendments to the underlying statute since its inception passed in 1969, sort of in law in 1970. And so I think you fast forward to today, and this morning, in fact, a few hours ago, the Supreme Court heard oral arguments in Seven County Infrastructure Coalition versus Eagle County. That's a case where Venable represented the petitioners, specifically our partners, Jay Johnson and Fred Wagner. But I think relevant to this discussion, it's the first NEPA case the court's taken up in 20 years. And whatever the decision, it's likely to affect how agencies consider environmental and climate impacts going forward.
Just for our audience, it's NEPA is the National Environmental Policy Act, which it deals with sort of the permitting process, sort of what agencies have to go through in order to do almost anything.
Yeah, that's right. You know, it's sometimes referred to as the Magna Carta of environmental statutes. So, you know, and that's you know, that's not the only NEPA development, right? Like in 2023, Congress substantively amended NEPA through the FRA, the Fiscal Responsibility Act, and you know, that's not all, right? You know, since 2016, the regulations themselves have been twice overhauled, right? First in 2020 in the Trump administration, and then again in May of this year, which was effective, I think, the 1st of July. And, you know, that's just one statute, right? So implementing an America First energy plan really requires, you know, a whole of government approach. And, you know, it's CEQ, it's Interior, it's Energy, it's EPA, it's the Army Corps, sort of all working together to advance a deregulatory agenda. And, you know, I'll maybe highlight a couple of things that the agencies, you know, will likely dig into in the first 100 days. But, you know, maybe I'll give a real world example on how these agencies actually interact with each other on development projects. And, you know, this is true whether it's, you know, oil and gas, whether it's a mining project, a railway project, you know, which was sort of that issue before the court today, or really any infrastructure project. So, you know, as you mentioned, there's NEPA, and it affects every major federal action. So if a federal agency determines that a permitting decision may result in significant impacts on the human environment, to quote the statute, then it'll require an environmental impact statement, which involves marshaling cooperating agencies and analyzing the proposal's probable impacts and alternatives, and conducting studies and modeling, and responding to public comments. And, you know, this is information I pulled from 2018, but it's likely still true today. On average, the process for energy projects takes 3.3 years, but for a quarter of the projects, 25% of projects, it takes more than 6 years, which you know, can be especially difficult as you're sort of starting in one administration with one set of requirements and then finishing with another. And again, you know, that's just NEPA, right? There's almost always Clean Water Act impacts on a project, which first require certification under Section 401 of the Clean Water Act. And then they require the Army Corps to issue a permit under Section 401 of the 404 of the Clean Water Act, you know, and again, but that's not it. Like major projects probably require, you know, the Army Corps to issue a permit under Section 10 of the Rivers and Harbors Act. And, you know, if you're impacting prior permits, you need sort of a 408 authorization. You know, you'll also need certification under Section 106 of the National Historic Preservation Act, and you'll need to consult with Fish and Wildlife Service under Section 7 of the ESA, the Endangered Species Act. You might need nest disturbance permits if there are bald or golden eagles in proximity to construction activities. And, you know, that's not even getting into Clean Air Act permits, which, you know, often impact these development projects. And, you know, those are just federal requirements, right? There are also state requirements. And depending on the project, you know, this all comes before the agency actually makes a decision to grant like the critical thing, which is usually a lease or a right of way or whatever else you're actually trying to do. And of course, at every step, there's litigation and, you know, usually one or more judicial or agency remands. So when projects cross administrations, you know, as mentioned earlier, it's, you know, sort of especially frustrating. And, you know, we had, you know, one client, you know, you sort of received nearly all their permits in the Obama administration. Those permits were defended in the Trump administration. And as sort of litigation progressed, the Biden administration sort of changed course, took a voluntary remand, and then ultimately revoked sort of a critical wetlands permit, right? And so you can see, you know, every agency sort of has a hand in this. And if one domino falls, the entire sort of project is at risk after, you know, investing, you know, tens, hundreds of millions of dollars, right? So I think maybe against that backdrop, I think we'll see the new administration try to streamline permitting by, you know, amending through rulemaking the regulations it views as particularly onerous. And, you know, I should mention here that like Democrats, you know, on the other side of the aisle are similarly frustrated, right? You know, I think the changes, you know, they've tried to implement are, you know, often more targeted, and they generally favor projects that align with their policy agenda, like things like, you know, solar energy or wind farms. But, I think maybe just getting specific, and apologies for going long, but I think CEQ will absolutely revise the NEPA regulations. This will most likely entail something like of a reversion, in my mind, to the 2020 rules that were promulgated under the last administration, the last Trump administration. I think that will reorient the effects analysis to something that's more akin to proximate cause. And I think it'll substantially narrow the Biden administration's inclusion in its phase two rule of considerations like climate change or environmental justice. And I should also say, that's all with an asterisk. There is a case out of the
Ask
DC
you about
Circuit.
that. Yeah.
Yeah. There's a case out of the DC Circuit, Marin Audubon, in which a divided panel held that CEQ lacks the authority to promulgate any NEPA regulations, as Congress hasn't, sort of specifically conferred rulemaking on what I think probably rightly was envisioned more as an advisory agency. And so I think how the new administration approaches, that issue in particular, we'll see. But I think it'll be, certainly for our practice, one of the most significant early decisions that the White House and the federal defendants in that case will ultimately need to make. I think beyond CEQ, I think it's clear that Interior, mostly through the Bureau of Land Management, will push to expand oil and gas production on federal lands. I think through the Bureau of Ocean Energy Management, known as BOEM, I think there may be a push to open additional waters for offshore drilling, offshore production. I think on the tribal side, which is a big part of my practice, I think there's probably efforts to promote self-determination and sovereignty among tribal nations through additional contracting or compacting functions under a statute called the Indian Self-Determination and Educational Assistance Act, or additional opportunities to sort of push down federal decision-making to tribes under the Indian Energy Policy Act. Just ticking through a couple of things, I think in the fish and wildlife space, you can see revisions to regulations that govern critical habitat definitions under Section 5 of the ESA, the Endangered Species Act, and maybe reconsideration of how costs are factored into listing decisions in the first instance, whether a species is endangered or threatened. And then I think finally, regarding national parks, this is a larger conversation, but there's probably, a decision that'll be made regarding the president's authority under the Antiquities Act to create in the first instance or diminish the footprint of national monuments, which are created by the executive branch. And maybe I'll just really quickly circle back to NEPA. Individual agencies, even if Marin Audubon is sort of the rule of the land, individual agencies would still be sort of primarily responsible for developing their own NEPA regulations, and then sort of adjacent to that, developing CADXs or categorical sort of exclusions or categories of actions that, in typical circumstances, would be sort of wholly excluded from NEPA. And I think it's reasonable that Interior and USDA and DOT and DOD and many other federal agencies would work to propose and codify new CADXs. I think EPA, just thinking about other agencies, I think there's so much to do in the EPA space. I think, guidelines for states to follow that limit CO2 emissions from power plants, that's an unresolved issue. The Obama administration issued its Clean Power Plan in 2015, which was replaced by the Affordable Clean Energy Rule, or ACE, in 2019, which was then vacated and remanded, in 2021. So I think the Trump administration will tweak that ACE rule in a way that I think complies with the law, yes, but in a manner that I think empowers and supports energy diversity. I think in the EPA space, I think the EPA will absolutely promulgate new regulations defining waters of the United States. The Biden administration, I guess in early 2023, attempted to expand the jurisdictional reach of the Clean Water Act, but was, through a sort of a parallel different litigation that had been ongoing, was forced to revise those regulations following another Supreme Court decision in a case called Sackett v. EPA. And so I think, although the new rule, which again wasn't subject to notice and comment, it removed a lot of the problematic sort of significant nexus standards, and it amended the definition of adjacent. I think in the minds of many, myself included, I still think it's overbroad. And then I think maybe finally, because I feel like I've taken up a lot of time, maybe I'll just mention one item under the sort of exclusive purview of the Army Corps. They're obviously involved in WOTUS and Clean Water Act decisions, but they're also responsible for about maybe nearly 60 nationwide permits that reduce pre-construction and notification requirements. And they also substantially reduce timelines that would be otherwise required by individual permits. So I think we'll see a continued sort of modification of those sort of periodic nationwide permit renewals that I think will, again, sort of further streamline permitting, especially for infrastructure projects.
Got it. Thanks, Kyle. That's a lot. Let me just ask you one last question, and kind of ties back to some of what we talked to John about with sort of personnel being policy. With some of the picks in the environmental space, Governor Doug Burgum from North Dakota, former Congressman Lee Zeldin for EPA. What's your sense of their approach to their tenure and leadership compared to maybe some of the other nominees or past nominees that the president has selected?
Sure, and I'll try to be quick. I know we're trying to get to other people. I think they have very different approaches, right? Governor Burgum, nominee for Secretary of the Interior, he's been governor since 2016. Before that, he was an entrepreneur, right? Sold a company for $1 billion, right? So I think that he'll bring that sort of experience as a business person to Interior. And of course, obviously North Dakota has, significant fossil fuel reserves in the Bakken, which, I think well suits him to advance the president's energy agenda. One sort of interesting thing about Governor Burgum, President Trump did appoint him to sort of chair a newly formed National Energy Council, which I think, helps with this, this whole of government approach that I was discussing earlier. And I should just note for my own practice, I think, Governor Burgum has built strong relationships with tribes. And so, there are 5 federally recognized tribes in North Dakota, one of which is a significant energy producer. 3 affiliated tribes are Mandan, Hidatsa, and Arikara. And, I'm hopeful that, he'll receive support from tribal leaders and continue to sort of advocate for sovereignty and self-determination in the mold of sort of past Republican appointed secretaries. Obviously, Lee Zeldin has a more of a political background, right? Served in the state Senate, served for 4 terms in Congress. But I think, as I think about those agencies and others, I feel like you're really, he's the head of the agency, but you're also appointing a team, right? And I think you saw that in the last Trump administration with, Ryan Zinke. And I'll just talk about the initial appointees because as people slide in and out, there are new folks. But, Secretary Zinke, he came from Congress. He was a member of the relevant House committee. But, his number 2 was David Bernhardt, who had been at the Department of the Interior and just about every job you could have, was the solicitor, congressional affairs. That was his deputy, and he had a lot of institutional knowledge about the building. And I think you can say the same thing about EPA under Scott Pruitt, right? He was somebody from a state that had been challenging Obama era regulations, but his number 2, Andrew Wheeler, was somebody with lots of Hill experience. He was the staff director, on Senate ENR. And so I think that, those 2 positions are obviously important, as is, the general counsel at EPA, as is the solicitor at Interior. Ryan Nelson was the original nominee at Interior. Originally, he had been practicing at the Justice Department as a younger lawyer in the Environment and Natural Resources Division. So I think you'll also want to look at DOJ and sort of who sort of fills out that assistant attorney general slot for Environment and Natural Resources, as that's really the entity that's responsible for defending these agency actions in court. And maybe I'll stop there, but maybe I'll just mention one more thing. In addition to these agencies, there are also these independent commissions that are usually 5-member groups. It's usually 3 Democrats, 2 Republicans, or 3 Republicans and 2 Democrats. I'm thinking about FERC as an example, Federal Energy Regulatory Commission. It's fully staffed, so unless something changes, it's going to be a democratically controlled commission probably until 2026. And I think you can say the same thing about the Surface Transportation Board, Nuclear Regulatory Commission. Those actually do have vacancies, so there'll be an ability to move more quickly to sort of a Republican-controlled STB, a Republican-controlled Nuclear Regulatory Commission. But they're not necessarily top of mind, and so there might be some lag on really critical decisions that do impact this sort of whole of government energy policy. So I'll stop there, Ron.
Great, thanks, Kyle. That was really, really helpful and informative. Let me, before we turn to Ariel, mention that for the CLE purposes, if you're going to seek CLE credit, the code is Administration 2024, all one word, Administration 2024. So you want to write that down and keep that. So Ariel, let's look at transportation and infrastructure issues. Something a little on maybe the other side of what Kyle was talking about at a certain level. What do you expect to see from the Trump administration? What will the priorities be for transportation, and how will they differ maybe from what we were seeing under the Biden administration?
Yeah, thanks. Great. And I too appreciate Kyle and John's comments there. It's very helpful. Let me actually just start with, of course, the caveat. I'm speaking in my capacity as partner of Venable and your colleagues, not on behalf of anyone in transition. And so it's just, based on the experience, share my observations from the first term. And I think some of the thought leadership that's been developed during that time and then until now, and some experience with US DOT in the years since. So to your question, Ron, I would expect there to be a shift in the focus to more, I don't know what the phrase might be, bread and butter or historic US DOT functions, building roads and bridges, kind of the basic work of transportation that we've seen over the decades. Now, to be sure, this is always what's been going on at US DOT to a large extent, but I think we should expect to see a more robust effort to get this done. And, part of this is a shift to a different kind of urban and rural mix and ratio. It's always kind of maybe not at the center, but it's present in the conversations of how this all works, but it's not confined to that. The reality is there are many competing priorities at the U.S. Department of Transportation, and really at a basic level, how the workforce is deployed on a day-to-day basis is the most fundamental demonstration of what the priorities are. And so just kind of getting back into or expanding kind of the road and bridges, highway type work is going to be something we should keep our eye on. We did see a lot of work and initiatives in the outgoing administration related to sustainability and climate issues, certainly over the past 4 years at US DOT. I think, it's safe to say there was also a focus on mass transit projects through the Federal Transit Administration and other kinds of big efforts and grant projects. We saw efforts looking at matters that touch on what's described as, environmental justice. And so at a core level, it's certainly not going to be surprising. I think we should expect a shift away from these issues and, again, to highway expansion projects, roads and bridges and related kinds of work that really are adjusting to natural population growth and shifts that have been occurring geographically, which is, in a sense, the core of Federal Highway Administration. And it'll include looking at grants and funding mechanisms and commitments in the electrification space, and finding ways to execute a shift in support of the priorities, right? In support of the adjusted priorities that we expect them to come in with. And so I would expect there to be a lot of scrutiny on what can and cannot be done and how to effectuate changes to some of the things that are frankly being finalized in the outgoing administration related to some of the commitments on electrification. I mean, there's going to be a discussion on that, I think, that's shaping up because of the flurry of activity that we're seeing there. So, that may or may not result in legal challenges or other kinds of things, but part of that is, I think, a natural, and you've been part of these kind of shifts over the years in administration and different parties changing, but kind of getting things out the door. And we'll talk about the regulatory side in a little bit, but this is separate from this, the Congressional Review Act and the regulatory things, right? Just moving a lot of money, frankly, very quickly in the waning days and weeks. And I'll just say, beyond all that, in a sense, to Kyle's point, there's going to be a big look at permitting reform. We really need to be focused on that. And literally about 90 seconds before you called on me, I think, I don't want to, I'm not trying to make news here. I think the president posted on Truth Social something related to anyone that invests $1 billion. I think the timestamp is 2:16 p.m. Eastern time, Ron. Anyone that invests $1 billion in a project in the United States will get like expedited permits, and he said, I think it concludes, get ready to rock. But more, detailed on the permitting reform side, right? This really hits home at the US DOT, right? In the first Trump term, there were significant efforts to get this done, and I think they're going to pick up where they left off. The one federal decision framework, which was, White House initiative, and other ways to in a sense, expedite the labyrinth of permitting requirements, which I think everyone can agree, needing an army of consultants to prepare reports and get ready for litigation, and that's going to be in the target site. And then maybe I'll just conclude this, just this note on the specific areas, turning to the elements of DOT. I don't think it's a secret that aviation matters is going to be near the top of the agenda. It includes regulatory measures that will come under scrutiny, but also, things like drones and advanced air mobility. A lot of pent-up innovation there. I think hasn't been any progress there, and that's not a knock on anybody. I mean, there wasn't. It's been taking a long time, I think, to work out the issues in that space. And then, of course, we expect to see in the area of autonomous vehicle technology, something that's been a long time coming across multiple administrations. I think we would expect, of course, there to be a push in this area from the president-elect's circle of advisors. And beyond that, there may be additional issues in rail and maritime. Final point here before is on the congressional side, the surface transportation reauthorization effort. So for those, there are times when you say there's going to be legislation, but there's no action forcing event. In transportation, just for those who aren't aware, the main programs that authorize transportation are set to expire every 5 years or so, and that's coming due in 2026. So 2021 was the big IEJA or bill, whatever the acronym you choose to use for that. That was the reauthorization then. And so the work on that is going to get done this coming year in 2025, usually. A lot of the writing, a lot of the thinking, a lot of all that. So I think on that front, expect there to be a good amount of conversation and input from congressional policymakers.
Got it. And what about sort of the appointments in the transportation world and kind of their approach? And maybe I'll ask maybe a corollary to that as well is, it seems like when we look at this administration, there's a lot of empty spots around, including some of the components at DOT. What do you see? Do you think the new administration will try and fill those faster, perhaps? What are we kind of expecting there?
Yeah, I mean, maybe the place to start here is at DOT. And this is true across the board, but I think at DOT especially, there's been a spectrum of how much leeway appointees at these different modes or operating administrations at DOT get from White House policymaking. And I think, whether it's the administrator of NHTSA, the National Highway Traffic Safety Administration, or the FAA administrator in different areas, I think this is a trend that's been going on for some time across the parties, but I think we're going to see it really accentuated here, which is a lot of efforts to coordinate policymaking from the White House. And so, in a sense, will continue, I think, a trend would be my guess of, having the nominees. There'll be some, they'll move forward. I think they're, certainly have expressed a desire to see those spots filled, but they're, I think the policymaking and execution will be really in concert with the White House. That'll be my expectation. I think you always see coordination with the National Economic Council, and then, to a certain extent, there'll be coordination with the National Security Council as different issues in supply chain continue to come up. But ultimately, Ron, DOT is a little bit unique because you have, the secretary and the secretary's office, the office of the secretary and policy there, but then you have these individual modes which focus on aspects of transportation. And I think in a sense, back to what I was saying before, the priorities Federal Transit Administration versus the Federal Highway Administration, right? Sort of like mass transit projects or transit projects. It doesn't have to be mass transit, but transit projects versus building highways versus NHTSA on getting automotive technology built out. Those reflect priorities, and so we'll see how the personnel and the appointments match accordingly. So that's something to keep an eye on.
Mm-hmm. No, absolutely. That's really interesting. And what's your general sense on sort of the overall, maybe even beyond the transportation space, kind of that deregulatory effort that we've been talking about, hearing from, the DOGE and everything else? What are you thinking, seeing, hearing, and whatnot?
Well, beyond the initial freeze, which is always in place, we would of course expect to see a ratio of deregulation at USDOT across the different modes. It was a 2-to-1 last time. I think there have been a number of different ratios expressed, and the other colleagues here talked a little bit about this. So there's going to be dereg efforts. We've seen regulatory measures advanced in the past 4 years, whether it's automatic emergency braking, in the surface transportation context, and certainly in the aviation context, in the consumer protection space, or the authority under consumer protection at the USDOT. And so, I think it'll be a high bar to get a new regulation moved forward in that area. That's not, certainly not breaking new ground by saying that. I think the exception, of course, as is true across different departments, will be legislative mandates to regulate. That AEB is one of them, and a couple of others that were put in. Every time they reauthorize, they're usually regulatory mandates, and so those kind of move in a parallel, different set of considerations. But then I'll just mention, we should expect to see, as always, kind of sub-regulatory ways to advance the agenda, issuing guidance and things like that. Although I will say there was a lot of work done at DOT in the Trump 45 team to, I don't know what the word would be, systematize or to get process around when and how guidance can be issued. Because there are, of course, drawbacks to having agencies issue guidance that aren't, they don't enforce a law, but they sort of say, well, it'll be really great if you do this or that. What do you do with that if you're a company or an industry? So, that there'll be a tension there, and trying to advance the agenda. And then last thing I'll just say is just keep an eye on how other developments in other agencies affect transportation. So, we've got the Department of Commerce rules on connected vehicles, supply chain related to countries of foreign concern, mostly about China. That's, expected to get finalized or move forward. The initial effort there actually started under President-elect Trump's first term through an executive order. It was expanded. So it's continued through. I think, should be straightforward to expect that to continue. And then just, what was it, about a week ago or so, maybe 2 weeks, the FCC, the Federal Communications Commission, finalized, after a very long time, a rule on vehicle to everything, V2X technology or spectrum technology. And, we'll see what that does. But those things in Department of Commerce and FCC and other agencies, they end up having an impact on what happens to USDOT in those areas. So, but the reality, Ron, I would just, in a sense, kick it back to you on the dereg space, because you do a lot of work here too, and maybe, kind of think out loud. You and I have talked about the Supreme Court's admin law decisions and the dereg efforts. And I would be curious, I'll throw it back at you, what your take is on, doing away with Chevron, Loper, and all of that. What does that do to help or hurt the administration's plans to roll back regulations? Like the nuts and bolts of it, how does it end up working?
Yeah, no, I think it's an interesting question. I think it's one that's going to really, you probably hit home soon as people try and figure this out, because, previously with Chevron deference, the agencies could generally do what they wanted within reason, and it would be affirmed by the courts with the deference they were given. And so I think, that at some level allowed for a back and forth, right? One administration could do X, the next administration could do not X, and each could justify it under a notice and comment rulemaking process. And so the question now, I think, will be when you don't have that deference, what does that mean from the challenge perspective? If you've got a regulation in place, maybe it's been upheld or maybe not, but, and from a judicial challenge, if it hasn't even been challenged. But if you suddenly decide you want to repeal that through a notice and comment rulemaking, and then someone challenges the repeal, you're kind of potentially at a loss to say, well, we get the deference to do this. You got to go back to what the statute originally says, and it starts to get a little bit messy or potentially difficult to figure out. And so, one of the things I've been wondering is there's, one way to repeal a rule would be to do notice and comment rulemaking, come up with the whole process, go through all that, deal with it, challenge that direction. But if you're someone who's interested in the deregulatory effort, whether it's an industry or a trade association, if you brought the challenge to the current rule and said, this rule violates the APA or whatever other basis of the challenge it is, in the Trump administration is then defending the rule that it's eager to get rid of potentially. To say, well, no, you're right. There isn't, it's not tied to the statute. It was arbitrary and capricious. It wasn't. Is there a way, do we see a situation where the administration is not defending the old rules, and sort of the challenge to the rule allows the administration to get rid of it much faster and more easily than if they had to go through that whole notice and comment rulemaking? And I guess, the way I look at it is almost, what's the status quo there in terms of a rule or not a rule or changing a rule or whatnot, and how that deference comes into play, or the lack of deference, I guess I should say. And so I think it could be an interesting area where people who might, be interested in a rule repeal would consider whether to go to court or go to the agency to try and get it done.
Yeah, Ron, I'll just mention this just off the cuff here, because I threw this out, I remember in 2016. Another way, and I'll just put this on the record here, maybe we'll publish something together on this. Another interesting way is to use the Congressional Review Act when you have complete control, is to actually issue, so the way it works is, right, to issue a rule, where I'm going with this, issue a rule that in the eyes of the administration is not a good rule, then use Congress to have the expedited CRA procedures to slap it down, and then no new rule can ever be issued in a substantially similar area, and just sort of clean things up that way. That's the kind of thing that you wonder, maybe we should, bring that up somewhere. But I think those are the kinds of ideas they might be willing to entertain, whereas I think, 8 years ago, it may not have been on the table. And it only works to have the complete control.
Yeah, exactly. And with as we were talking about with John, kind of the close margins may mean some of that's a little bit tricky to do or risky to do, but it certainly could be an effective tool to clear things out or block kind of those regulations. And that sort of, I think too, that pendulum of the back and forth is one of the whipsaw effects that really complicates kind of modern life with everything in place here. I think we're nearing the top of the hour. We have just a couple of questions, but if anyone has other questions they want to submit, we might have time. We do have a whole series of webinars coming up with different areas, particular topics. We do have one question about sort of the Federal Trade Commission and antitrust. I think, whoever, Kyle, Ariel, John, if you want to comment on that. I mean, my sense is that antitrust is a really interesting area these days. There are, certainly some Republicans that take a very sort of almost left view of sort of antitrust and very aggressive enforcement, particularly in certain industries. And so where that all nets out, where that shakes out, will be an interesting, I think, situation to kind of track and follow. That it might not be just the easy, antitrust enforcement kind of goes away in this administration. It could ramp up in certain areas. Any of you, like colleagues, have any thoughts there or want to comment?
Not really. You guys are the lawyers, so that's a legal thing.
Yeah, I mean, to your pendulum swing comment, Ron, I mean, it's going to be, I think, dramatic here. And I don't have much more to add in that respect, but it's certainly been at the forefront of, what the incoming administration has been talking about. Although it is, I think, not as black and white politically as some might think. So that'll be certainly on the technology side.
Absolutely. And I believe we have we have had a couple of different questions on tariffs, but I believe we have a whole separate webinar coming up on trade down the road. And none of us on here are trade experts. So I would not dare to answer questions about the different tariffs and whatnot. So please do stay tuned for when we do sort of the trade section there. I think kind of want to thank everybody for attending today. For the CLE folks who are looking to obtain CLE, the code again is Administration 2024. So please make sure you do submit that. Our next webinar will be on Thursday, December 12th. So coming right up. This one is going to be on the reconciliation process that we talked about in a lot of detail, or in some detail with John earlier in our session. So this will be really the nuts and bolts of how that reconciliation works. And then as we mentioned before, when I had the question about trade on December 17th, we will have the tariffs, tools, and international impact webinar to really cover that. So if trade is what your focus is, that will be the one to cover there. So again, thank you all for attending today. I hope it was helpful. You'll have some follow-up materials coming out afterward, and look forward to the additional webinars coming up that we hope you'll join us for. So thank you, everybody.
Thanks.
Thanks.